Good morning.
Hello everyone, good morning.
Pleased to meet you.
Hello, everybody.
Michael, the next item on our agenda is the matter of Alfredo and the dispute with his tenant.
Okay, what have you got?
It is important to first note that as the lease is registered, it provides the tenant with a level of protection under the Land Title Act. It is noted that our client Alfredo wants to have the tenant removed from possession, but given the high vacancy rates in this area, it should be seriously considered whether this is the best course of action. The client should be advised that perhaps a negotiated approach to a resolution of the dispute would better suit his interests. The first issue that we feel necessary to raise is the incentive payment that the tenant is pursuing and whether or not Alfredo is in fact obligated to pay this. When the predecessor in title let the premises to the tenant, a covenant providing for a $35,000 annual incentive payment was included in the lease. It must be determined whether this covenant transferred to Alfredo upon assignment of the reversionary interest. The decisive factor here is whether the covenant touches and concerns the land as required under the Property Law Act. It follows on from case law that the payment would likely be considered a personal covenant and not integral to the lease. Therefore, it is our view, Alfredo does not bear this burden on his interest. The tenant will likely argue that she would not have entered into the lease in the absence of such a covenant. On this basis, legally Alfredo does not need to negotiate on this point. However, we will review this when discussing potential options for a resolution.
Thanks, Jason. The second issue we will talk about now is that of Alfredo's tenant's concerns with regards to disruptions to her business by an adjacent tenant within the complex. The tenant may pursue actions within the implied covenants of quiet enjoyment and non-derogation from grant. It will be our view that given that Alfredo was not authorised or encouraged the behaviour of the tenant in Suite 2, it is unlikely that he will have breached the implied covenant of quiet enjoyment in this circumstance. Further to this, when Alfredo entered into the lease arrangement with the tenant of Suite 2, he did so under the understanding that the tenant would be using the premises for predominantly online ticket sales. There was no reasonable understanding that could be attributed to Alfredo that he would have known that the tenant would use the premises in a disruptive fashion. On this basis, we would advise that Alfredo has not breached his duty of non-derogation from grant. The tenant of Suite 1 may allege a breach of implied covenant of quiet enjoyment when Alfredo delivered a handwritten notice terminating the lease. Given Alfredo's failure to comply with the requirements of notice, it is conceded that he may have breached this implied covenant in this instance. This will be a point of negotiation where concessions may be considered.
Thanks, Tony. The third issue we will be considering is the rent in arrears and repairs the tenant has failed to maintain. While the Property Law Act gives a statutory force to the requirement of the tenant to pay rent and maintain the property, Alfredo also has obligations under the Act when seeking to remedy this, which he has failed to fulfil. The tenant may argue the rent was withheld to bring pressure to bear on Alfredo to pay the incentive payment. However, the law is clear in this regard that the mutuality of covenants does not apply. The tenant would need to pursue this argument as a breach of contract. We will now consider the options available to Alfredo, where we have developed 3 different negotiating options for him to consider and provide instructions. The first option to be considered will be to remove the tenant from Suite 1 and pursue damages for rental arrears with interest, reimbursement for repairs to Suite 1 and future damages for loss of reletting. In order for Alfredo to achieve this, he will need to forfeit the lease. This will require Alfredo to give notice of the breaches in not paying rent and maintaining the property. If after a reasonable time these breaches are not rectified, Alfredo will be in a position whereby he could forfeit the lease and pursue the remedy in a court of law. Alfredo will need to be aware that this will be the most expensive and riskiest option available to him, where a judge may not award all of the claims he is asking for. On this option, the tenant of Suite 1 will likely seek to enforce her rights and hold Alfredo to account for any breaches attributable to his actions. Alfredo will need to take into account the economic climate due to the mining downturn in Townsville and the high vacancy rates. There is the possibility that Suite 1 may sit vacant for a lengthy period.
Thanks, Melissa. Now, in considering the likelihood of this lengthy vacancy, a more moderated approach may be beneficial to Alfredo's interests. To mitigate this risk, allowing the tenant to remain in Suite 1 would be an option to be considered. The tenant in Suite 1 has indicated a preference to remain in possession of the premises, where any derogation from this would likely have a significant detrimental effect on the tenant's business should she have to re-establish in an alternate premises. This provides an opportunity for our client to exploit this position. In this option, we would advise that we would not make any incentive payments, would demand repayment of rent that was in arrears, and require all repairs to be completed in exchange for not pursuing a forfeiture of lease and allowing the tenant to maintain her interest in Suite 1. We would also require any potential breach action brought on by the tenant to be withdrawn and not pursued. In the event that the negotiation is hard fought, Alfredo's interests may be best served in allowing some concessions. Under this option, we would advise that the tenant is allowed to remain in Suite 1, where consideration could be given to a negotiated incentive payment. Under this option, we would demand repayment of rent that was in arrears and require all repairs to be completed in exchange for not pursuing a forfeiture of lease and allowing the tenant to maintain their interest in Suite 1. We would also require any potential breach action brought on by the tenant to be withdrawn and not pursued. Given the options available to Alfredo, we think in the current economic climate it will be prudent to take into consideration the high vacancy rates within Townsville, reletting costs and expenses, and the high cost of pursuing legal action in the courts. In keeping this in mind, the option we would advise Alfredo to consider is option 2. However, it will need to be understood that this may change during negotiations. We would need to seek further instructions from Alfredo in clarifying these options with him.
This really is excellent work. Well done, team. This really is excellent work. Well done, team.